day to all you students, teachers, and the generally curious I believe this is the 10th episode of the Constitution and American Life with us, the Friends of Publius. You know, I'm kind of generally curious about something, and I think both Chris and I read an article from The Atlantic there. So rather than do my traditional bloviating for a few minutes, I thought I would touch base with my colleagues here and maybe get their general thoughts of what The Atlantic called the history wars. Partly I was attracted to it because it involves the University of Wisconsin, which Professor Moore there is employed by, and then one of the harsher critics of the American Historical Association's president, who resides at the University of Wisconsin-Madison, is from the University of San Diego, which I'm always impressed when someone from the University of San Diego gets national attention. So the issue really, it's called the History Wars due to the president of the AHA wrote a short little essay. And in his mind, he was just trying to generate the traditional discussion that those of us who studied history both in college and as we maintain our life in the study of history, really address the question of why study history, and should we study the more distant past to explore its strangeness and thereby jolt ourselves out of easy assumptions that the world we know it is the only possible one? Or should we study the more recent past to understand how our world came into being, thereby learn some lessons for shaping the future? That comes from the Atlantic article. To make this fit for more of a bumper sticker, we can phrase it as presentism, a word you've heard on this program over and over again. Presentism versus antiquarianism. All right. Suffice to say that the spectrum of people in the field of history are speaking with loud voices, pointing fingers at each other. Simply, minor presentism is kind of using history to pursue possibly political objectives or justice in the present time. Antiquarianism is, the study of the history. It gives us some insights into possibly the human experience, but it's not going to really give us, answers to current problems per se. So I was wondering where all of you guys, kind of briefly are on these history wars there. So Professor Williams, since in the University of San Diego, and I honestly I don't have the guy's name right here. I didn't know if you knew this history professor. I guess it doesn't mention the professor's name. Maybe it does later in the article. Where are you? Why study history? Should history be used as evidence to pursue current issues of justice, current issues of public policy?
Sure. I mean, it should. I mean, history is about stories, right? And the stories we tell definitely matter. And without reading the article in depth, to be honest, and just kind of responding to your prompt, I think there's room for both. In fact, I just heard something on the radio today about, I forget this was in California, but it's this notion of how do you incorporate more Asian American history into the classroom. I think this was a high school classroom. And these teachers had decided to do it where they were going to talk about it throughout the entire year at different moments. So today the teacher was talking about how he was telling the students about the Filipino Farm Workers Association and how that worked with alongside like Cesar Chavez. And the notion was, we can understand different moments in American history and understanding different stories along with that. And we can have the students kind of think about, the relative importance of each. So I think there's room to do both. And I think, it's kind of loaded the way you phrase it. Should history be used like currently to put the thumb on the I don't know, the pendulum of political debates, I would say that's already being done. So it's being done in a way that maybe is invisible to us. So I don't see the issue with bringing history in to further those debates if it's even a different history.
Yeah, and in all fairness, this issue is far more complex and multi-layered, of which I didn't want to take the time to spell it out. There's a lot of different issues that are brought out in the article from the Atlantic. And Chris, you read it and shared it with us. I had, because I get the Atlantic. I had read it a few days before. What were your thoughts?
Well, by the way, it was Dr. T.J. Talley. Does that name ring a bell?
Oh, yeah.
That's the San Diego professor that wrote. But it just really, according to Sweet, he was not prepared for the blow up. Part of it too is I liken it to the fact that what we have in this day and age, and I got to be really careful here because I'm going to tread lightly. But my comparison is like there might be some people that would say, well, why do you have a straight actor playing a gay part, right? And it's, you've got Professor Sweet, who's bona fides in the study of Africa, African culture, the slave trade, is pretty legit from what I understand. So there's part of that as well. And certainly there were some historians calling the whole idea, and Michael was alluding to, using history for activism. And I'm a big presentist kind of guy that, if I'm teaching history with kids, I've got to make it relevant. So I've got to draw a line from, that maybe the ancient world or the historical world to today to make it relevant for high school kids. But in the academy, I think it's a little different. So I don't know, I was a little, I don't want to say upset, but I didn't quite understand all of the anguish sent towards Dr. Sweet from folks about what he had written. And again, that's probably because it's way above my pay grade with folks in the academy and in their ivory tower. Oh, did I say ivory tower? My bad.
Professor Moore, since Professor Sweet, he's the president of the American Historical Association, resides at the University of Wisconsin-Madison. I'm just curious, I'm sure there has to be some chatting going on campus, or at least in the towers.
Yeah, most undergraduates don't even know what's going on. Most of the discussion is amongst grad students. Yeah, I think the article did a good job laying out the one of the dilemmas of modern history is it, and Chris has already alluded to this, is history to be used as activism. Now I don't know where that line is, where a good history crosses over to activism. Because honestly, even in the article from mentioned Bancroft. Well, Bancroft's history in the 1800s was advocating a national narrative, and so I don't know that I would call it activism, but there certainly was an agenda to Bancroft. As most historians, there's all their objections aside, there is an agenda. But I think a part of it that I thought Fromm didn't address particularly well is I think a lot of historians view themselves in a class struggle or some sort of Marxist struggle, and the framework of clash and activism. I know some critics of it have called it cultural Marxism. But there's this assumption of that there's going to be this automatic, I don't want to use the word anarchic dynamic to your use of history, but history should be used to tear down all vestiges of power, or in some illegitimate power needs to be addressed. But the activism piece, as it relates to this dialectic, almost, I think has been used by a lot of historians in the last couple generations. I thought that could have been brought out a little bit more. That might explain the visceral response and the unbelievable response to Jim and what he had written in the AAH journal. So I feel awful for him, because he's a great historian. He's very approachable. So I feel terrible that he's been hollered at by everybody, by a lot of people who don't even know who he is, and maybe that's my communitarian coming out, that maybe we ought to know each other a little bit better before we start lobbing grenades.
Badgers got to stick together.
Well,
I'm
not gonna get tribal here with this, but
no, but I think your point is well made. Is that people are so in this day and age, and maybe this speaks to me as my generation, is that I was a little taken aback, because I really didn't know much about this situation until I had read the piece. I'd kind of heard about it, and I know that David had alluded to it, but I was like, oh my gosh. People were really quick to throw a lot of stones at this guy, and his bona fides are pretty solid, and he knows what he's talking about. And if the whole purpose of what he wrote, as I understood it, was to pose questions, and I thought those were all valid questions.
And go ahead, Mike.
Well, just in that spirit, Professor Talley has an office across from mine, and if you guys were to meet him, he's an intellectual gem, and he is a voice not only of activism but of a lot of reason here on campus. So again, having not looked at the article, I don't want to dive into the details, but I just wanted to bring that out about him as well, that he has his own sort of story to tell as well, and I think the three of you would really enjoy his company if you were in San Diego.
Well, we should get him on the show.
It won't stop us from using presentism, by the way. Some of us are firmly grounded in that. But for teachers and even possibly students, if you're more interested in the idea, it's called The History Wars from the Atlantic magazine article. It's a fairly recent article, but it was also, Chris, I first came across it in the New York Times. So the stories reached the New York Times, the Washington Post, and then others. I think it's a wonderful discussion, to be quite honest. Reading what Professor Sweet had written, I fully agreed with him on some of the problematics of changing history to meet a narrative for contemporary purposes there. And it seemed to me he was somewhat bothered by the changing of the historical, in some case, facts there. Yep. But the discussion's been going on for a long time. We know that the history of Reconstruction seems to have always had some political purpose and presentism involved in it. So something for everybody to gnaw on, and somewhat related to that last statement on Reconstruction. Tonight, we're going to be looking at the 14th Amendment and the doctrines of the state action doctrine, the incorporation doctrine, and the application of the Equal Protection Clause, which these are all very relevant issues, and given what I call the post or the potential counter-revolutionary nature of the current Supreme Court and their use of history. So let's begin our discussion with the historian from the University of Wisconsin, Professor Moore. From my understanding, all right, let's look at the Bill of Rights first, because the incorporation doctrine obviously includes that. From my understanding, James Madison wanted elements, since he had the primary task of writing these the amendments in the first Congress, that he wanted elements of these rights to apply to the state government. Why was that? What was Madison's thinking motivation, and why didn't at least some of the Bill of Rights apply to state governments in the initial 60, 70 years of our history.
Well, Madison, I think there's a lot that goes into Madison's motivation. Essentially, you're referencing James Madison's 8th of June speech, 1789. He finally gets his fellow Federalists in the first Congress to table their discussions about, taxation and all the real important stuff. And most of the Federalists are basically just, okay, do your long speech, and then we're going to go back to regular business. But in June 8, he lays out the reasons why there's a Bill of Rights that's necessary. And in the middle of it, he proposes, and actually he wanted these rights incorporated in the body of the Constitution. And then Sherman eventually persuades the House that maybe they should be separate. But in that speech, he proposes that he uses the phrase "no state shall." And he wanted states to be restricted on the rights of conscience. He wanted to restrict states in their abilities to abridge the press, and he wanted to clip the wings of states when it came to jury trials and criminal cases. Now, as to what's going on there, I think there's probably maybe 3 or 4 reasons why he has this inserted in this June 8 speech. Number one, it was interesting. A couple of years ago, we had a symposium, and one of the professors said, if you really want to understand Madison's Federalist 10 argument, you have to understand Madison's fight against the religious assessment in Virginia. In other words, states, the state of Virginia in this case, was running roughshod over religious minorities. So Madison saw that firsthand. Baptist pastors getting the living daylights beat out of them, and so there were religious minorities in Virginia that were really taking it on the chin. So I think a part of Madison's motivation to want to restrict states goes back to the 1780s in Virginia. It also, I'd say, see his vices. He writes this long internal memo to himself right before the convention. And he lists, it's a real long, believe me, and it's hard to read because it goes on and on and on and on, and it's very small handwriting. But he lists all the problems that states are representing in the 1780s. They're abusive. So I think the Virginia assessment debate, I think his vices is another layer here. Look, he also was scared to death in 1788 of a second convention. Now, that would run counter to him wanting to restrict states in this speech on June 8, but that in a larger way motivates him to advocate for a Bill of Rights. He doesn't want a second convention because then states would really run roughshod over the Constitution. And again, to his point, states are the problem. So I think there's three things there that go into his motivation for that speech, but he definitely lays out 3 things which he perceives as to be the biggies: conscience, press, and trial juries would have restricted the states in his Bill of Rights.
And I assume that he loses, not that that his advocacy is defeated just for the same general principles of anti-federalists. Federal versus state power. It
gets through the House, and then the Senate takes that out. In early September, the Senate boots that, and they clean it up. They condense. I think there were 17 statements that went to the Senate, and the Senate kind of streamlines it, but they do eliminate the "no state shall" provisions that came from the House. And there's 2 rabidly anti-federalist senators from his state, Virginia, that had a hand in making sure that that no state provision didn't get through the Senate.
But he wasn't alone. Is it accurate to say that he wasn't alone on this belief about states being possibly more of a threat to the rights of the people than the national government?
Oh, no. Yeah, he's not alone. I mean, that goes back. I mean, Hamilton was writing against states in 1781. The war wasn't even over yet. So the Continentalist Essays addresses the states running roughshod over the national economy and the inability of the national government to get anything done. So yeah, there's Gouverneur Morris, Robert Morris, James Wilson saw firsthand his own state that ran roughshod.
And I understand the whole economic argument, and when we start to get to Article 1, Section 8 powers, but just looking specifically of the rights of the people. And it was like last year I read Hamilton 1781. They were talking about economics, taxes, trade, things like that. But these, in some ways, are more about fundamental rights. Were they on board with Madison as far as that goes too, or at least was Hamilton on board with it?
Yes, but by the time the issue comes up in Congress, again, there's more Federalists interested in the economics of taxation. I mean, there's still, even in the first Congress, I think it was Thomas Tudor Tucker. He actually proposed in response to Madison's speech about a Bill of Rights. He still wants this requisition system, that Congress should still be limited in requesting funds. And he makes the argument that if they're not limited to just requesting funds instead of direct taxation, it's a violation of rights. So a lot of people in the first Congress saw money and rights as connected. Property. We've talked about that quite a bit in the past as well.
So Professor...
and one more thing. In the June 8 speech, interestingly enough, Madison reminds all those Federalists in Congress, in this context of this no state shall that he wanted for those three things, he reminds everybody that states are the problem because there's restrictions in the Constitution on states. They can't, Bill of Attainder, they can't do that. They can't address ex post facto. So he reminds them of states being the problem. And then that's kind of coupled with his agenda for wanting religion, jury trials, and press.
So Professor Kavanaugh.
Well, Dave, before you ask me, students need to remember too that Madison wanted the national veto, right? He wanted that. He tried to get that in the body of the Constitution at the convention. He lost. He considered that his most important amendment in his list of 17. That obviously got struck out, as Tim just alluded to, by the Senate. They weren't going to have that. And so the whole idea that, wanting how would that you play the what if game with history, given our introductory discussion, how does that change things if the national government has the veto over state laws? And I'll also go to Article 1, Section 9, or Article 1, Section 10, the obligation of contracts, because the states they're not honoring contracts, and people that were owed money, the states were just stiffing. So there are some individual rights there as well. Sorry.
Well, I think, before in some cases the students get to maybe more of the meat of the questions that they're asked to deal with, that they really have a solid background in the 14th Amendment, since this whole question does deal with that, maybe in smaller pieces. And, Jeffrey Rosen at the National Constitution Center, and he, along with many other scholars, have called the 14th Amendment the second constituting of America. To what extent, Professor Kavanaugh, do you agree with that? And as part of that, to what extent did the 14th Amendment in general alter the federal system of government?
Well, I definitely would agree. I would definitely agree. We'll do this. We'll list in resources, but Eric Foner, Professor Foner's book called The Second Founding is really good. I will include a link to one of my favorite allusions to this very topic, and that is from Justice Thurgood Marshall. And he's giving this is the San Francisco Patent and Trademark Law Association meeting in 1987. And he's talking about, the bicentennial of the Constitution. And it's kind of like asking, Frederick Douglass, what does the 4th of July mean to a slave, right? And so Thurgood Marshall, as a justice on the Supreme Court, and I'm going to make sure I've got this right, that he said the Union While the Union survived the Civil War, the Constitution did not. In its place arose a new, more promising basis for justice and equality, the 14th Amendment, ensuring protection of life, liberty, and property of all persons against deprivations without due process, and guaranteeing equal protection of the laws. So I would agree with Jeffrey Rosen and the multiple scholars that would say that the 14th Amendment was absolutely changed the game, so to speak. But I want to qualify that to the second part of your question, David, and that is for a little bit. It changed it for a little bit. And that is until, say, Rutherford B. Hayes comes in as president. And also, in a case that I'll include in the reference section is Cruikshank versus U.S. And because of the Corfield Massacre in 1873, where Louisiana, white folks in Louisiana killed Black folks exercising their political rights. And it goes all the way to the Supreme Court. And the Supreme Court says, oh, well, that's a state issue. We can't make sure that justice is served here. So there's a window of time where the 14th Amendment really could have changed the game had we followed through on Reconstruction. But because we don't, that window closes. The 14th Amendment is set aside. And before you know it, at the end of the century, you've got corporations getting protections under the 14th Amendment that it was not intended for. If you read the words of John Bingham or Jacob Howard, the two framers of the 14th Amendment, that was not what the intention was. So,
well, the window, but in the march of history, the window opens for a brief period of time, the window closes for a prolonged period of time, but eventually the window is reopened. And I'm going to editorialize and say we might, at least, in more recent times, we might see the window starting to be closed again in some ways. But you would agree that, by the mid 20th century, the window begins to reopen and the 14th Amendment.
Sure. This is my students came up with this years ago, and I remember using it when Professor Kaminsky was judging, and one of the kids had referred to the 14th Amendment as Madison's revenge from the grave, right? So the idea of that national veto I just mentioned, the ability of the national government to tell states you can't do this. We end up getting that through the 14th Amendment and the incorporation doctrine, where through the Supreme Court, on a, as we know, case by case, right by right basis, the court has said, by the way, states, you can't do that because that's a violation of the 14th Amendment.
Well, do you think when it comes to, without getting into real specifics, but just the general tone of the 14th Amendment vis-a-vis the federal system of government, do you think that it is Section 1 or Section 5 that has a more profound effect on the system of federalism?
Yes.
There's a Tim Moore answer.
I think that, well, clearly, you have to go back to really, I would say, the 13th Amendment and the second section of the 13th Amendment, which is the Section 5 of the 14th Amendment, and it's the second section of the 15th Amendment, which we start to see the enforcement clauses. So yes, Congress has the ability to enforce this amendment through appropriate legislation. And then the student should ask, what's appropriate? I don't know. What's necessary and proper? It's that same kind of issue there. But without the language in Section 1 that was clearly designed, and again, Bingham has said that John Bingham, who was the author of Section 1, it was there to curtail the power of the states. He says it. I mean, he says it in many places. So I think that if we want to talk about originalism, pause for effect, the whole idea of what did he say, the framer of this amendment say, it was there to curtail and limit the powers of the states. So I think that's important for us to understand. But I get your question, David. I think it's hard to say Well,
here can I clarify, because to some extent that's like a stupid question. Section 5 doesn't mean anything without Section 1. But I guess here's my dilemma: is Section 5 specifically identifies Congress. Yet we look at so many applications of especially rights. All right, it's not Congress that's doing it; it's the courts, and so that's why I kind of segregate them out and say Section 5 says Congress has the power to enforce these, but Congress doesn't take a lot of action. All right.
Well, not recently, but if you think of the Civil Rights Act of '64,
but between that, but before that, you have numerous. I mean, heck, we can go back to the Equal Protection Clause in Chinese labor in the 19th century, right? So to me, it's the Supreme Court that's doing this, not Congress, and therefore Section 1 would have more importance in the federal system than Section 5. That's where I was at.
Far be it from me to defend Congress, because I've made my thoughts known on that group of lawmakers historically. They have used that power. Could they have used it more forcefully? Yes, but they have used the power in the past. But this is a modern issue, I think, David, you're alluding to, because now they step out and we let the courts step in and they make that binary decision, which is very frustrating. It is a right or it isn't a right, which is that is frustrating in itself. The idea that you either have it or you don't.
I would add to that. It seems to me that you can see Section 1 is laying out sort of the floor and what the new boundaries are in our politics, right? Like saying these are new boundaries. Section 5 it's a political question. It's leaving it up to future generations to define how they can operate within those boundaries. So I agree with Chris and Dave, kind of what you're saying. It has been a failure of Congress, but it also has been, and we can get into this more later, like because the Supreme Court has so much power in interpreting the words, because the words are so vague. Like, we don't want to write too much in our Constitution, like a lot of other countries. It means that the court can look at the 1965 Voting Rights Act, right? Or look at something and say, well, this isn't consistent with a constitutional provision, and thereby constrain what Congress can do as well, right? So it's frustrating on two ends that Congress has not exercised, I think, its power as much as it could, but it's also frustrating because we have not been as maybe specific and precise in our language as other countries have, that it gives the justices more latitude to read into what these words mean. And that opens it up for politics to play within the court as well.
Professor Moore, you were going to jump in a while ago. Is there?
Yeah, I think your point was well taken, David, that and this might be kind of a little pushback on Chris, that is this a second constitutional? Is this a second constitution or a second founding? I mean, it could be, but I find it interesting that the court has had a role in curbing this constitutional revolution, the 14th. I mean, they did it in Slaughterhouse. They did it in the civil rights cases. Where Congress did act in the civil rights cases, that case, the Civil Rights Act of 1875, I think. So the courts had a role of saying, no, we're not going to go down this road. And then the court has also had a role in expanding the meaning, that whole 20th century March of Freedom type story. So I think that this if it is a new constitution, I find it, I'm not sure it's the same as our first constitutional revolution, because the court has had such a heavy role in this revolution unfolding in terms of protecting rights or not protecting rights. So the role of the court, I think, is a good point you've made, that it seems like this ought to be in the hands of the legislature.
Well, I'll include this in the references, but I'm listening to a book now by Professor Jamal Green. I think he's at Columbia. If I misspoke, I'm sorry about that, but it's How Rights Went Wrong. And it's very fascinating in terms of taking a look at justice versus rights. And it's a very compelling read, or in my case, listen to. So I will include that, but it really speaks to that. And I think that, Tim, your point is well made about the court. It plays a larger role here. and maybe an outsized role because Congress has chosen not to, or that people will challenge like the Civil Rights Act as well and push back. So it throws it to the courts as opposed to the legislative branch.
Yeah.
Mike?
Yeah, I just want to add, I'd have the students on this point think about history and think about, see if we're right. See if there are limited times where the Congress has stepped in to advance civil rights. But then think about the opposite. I mean, David recommended a book, American Midnight, that I'm reading right now by Adam Hochschild, and it's about the period from 1917 to 1921. Think about all the times in our history where Congress has had little to no hesitancy to step in to limit rights, right? Before the Civil War, after the Civil War, after the progressive movement, after the civil rights movement. I just think it's something, as you're learning these periods in American history, students, to start to think through what narrative, what story that is telling about what Congress at some times is capable of doing and at other times is not.
So, to kind of focus now, one of the doctrines of the 14th Amendment that is still controversial, which might surprise some people, is the doctrine of incorporation, which plainly said, if I can do that, is applying the rights in the Bill of Rights to the state governments, which we've already talked about was something that James Madison wanted to do in a kind of a more limited, narrow way with some rights, but applying those rights in Amendments 1 through 8, possibly to the state governments. There's some debate over whether or not the Privileges and Immunities Clause was going to be the mechanism to do that, but the 20th century court will end up using the Due Process Clause. So my question to you, Professor Williams, is it surprised me a little bit that there is some writing out there by law professors and some historians that reject the doctrine that incorporation is really, a judge-made kind of principle, that it wasn't the intent of the framers. And in fact, that includes at least 2 members of the current court reject the doctrine of incorporation. And so I'm wondering, how would you respond to those who say, no, they never intended that? What arguments would you present to support the doctrine of incorporation from the 14th Amendment?
Yeah, so let me start with a couple big ideas, and then I'll try to get more specific. I'd have the students think about the most uncontroversial definition that you can come up with of what it means to live in a liberal democracy, or a liberal republic, democratic federation, whatever we want to call it. And the most uncontroversial for me that I share with my students is free and fair elections and the protection of basic civil and political rights. So I'd have you just think for a moment now what it would be like to live in a polity where those certain basic political rights were protected at one level of government and not protected at other levels of government. And to just ask yourself whether then that would meet the definition of liberal democracy. I don't think it would. So I think one non-constitutional law argument is just to think through, if we're going to have a liberal democracy, then surely the states have to be prohibited from violating the very rights that are protected at the federal level. My second big point is just to kind of chime on to what Tim and Chris have already pointed out, that this debate is a long, long debate. I mean, the debate over national versus state power is one that goes back to our very roots. And it's one that we shouldn't be surprised that we're still having. And to answer David's question, no, it doesn't surprise me that there are 2 justices and legal academics who are entertaining this, because it's part of one of the big issues that we will always debate as long as there is, I think, an American system. And then I guess to get more detailed here, I think that if you were to look at the intentions of the drafters of the 14th Amendment, I think there is evidence that at least some of them thought that through the Privileges and Immunities Clause that the Bill of Rights, the Federal Bill of Rights, would be incorporated. Now, they didn't write that, right? It could have been put in text, right? That no state shall violate any of the rights protected in the Bill of Rights. And this gets back to what we were just talking about. Because it's not clear, and because privileges and immunities could mean a lot of different things at different periods of times, and now that the court has, in the Slaughterhouse case has gutted it, we are now in a situation where I think there is a political and cultural impulse in the 20th century that we are liberal. We want to become a liberal democratic society. And you can't do that if the state of Rhode Island can take away your free speech rights and you go to court and argue there's a First Amendment and the court says, oh, sorry, it doesn't work. So in our system of government, unless Congress were to step in and draft legislation, right, it's the role of the judges to interpret it. And the role of the judges, I think reasonably have said, well, no state shall deprive any person of life, liberty, or property. Liberty must include what's in the First Amendment, right? The right to free exercise of religion, the right to free speech. So we're going to selectively incorporate that. I think it's reasonable that the justices have been doing this. I think it's not out of my imagination now that my grandkids or great grandkids might be living in a society where some of those rights that have been selectively incorporated justices may decide to not have them incorporated, and that we might live in a place where there is much more discretion for states to limit rights in ways that the federal government cannot. So I guess
I applaud your optimism that your grandchildren or great grandchildren are going to even live in a democracy. So I really do applaud that. Chris or Tim, thoughts on what Mike said, or anything?
I'll just quote John Bingham here, author of the primary part of the 14th. The Congress shall have power to make all laws which shall be necessary and proper to secure this to the citizens of each state all privileges and immunities of citizens in the several states, and to all persons in the several states equal protection in the rights of life, liberty, and property, as Mike just said. And I think that these guys, to use my originalist position, these guys would be aghast that the Bill of Rights didn't automatically apply as a protection against state governments. Their intention was to protect people, the newly freed people, from state governments. It's clear throughout their writings. That was the purpose of the 14th. And because we have a court that is worried sometimes about, well, gosh, if we do this, does this mean this invalidates all this other stuff that we've done? And so you see a court that nibbles, right? They nibble around the edges sometimes, which is very frustrating because they're worried about having to go back and make changes. And we see this in multiple opinions through the court's history, that we don't want to say, well, this is clearly what the law says, but if we make this decision, gosh, we're going to have to go back and make all these other changes. Case in point would be Justice Thomas writing in McDonald versus Chicago, which is the incorporation of the Second Amendment against, and we know D.C. v. Heller was the first case, but then McDonald versus Chicago. And Justice Thomas uses the privileges or immunities clause of the 14th, because it's clear that it's laid out in at least one brief that I know of that to bring that back. And he says in a footnote, I understand that by opening this door, so to speak, by using privileges or immunities, it may open up other rights claims. And we're talking about, same-sex marriage, to protection of the LGBTQ community. But that's my frustration with this selective incorporation. That's not what the framers of the 14th Amendment intended.
So, Professor Moore, you will hear quite frequently that the clauses of the 14th Amendment, especially the Equal Protection Due Process Clause, were intended to only limit the power of government, the state action doctrine, no state shall. Yet there have been numerous cases over the years that involve private organizations. What is the constitutional rationale behind allowing state and national governments to regulate private organizations in relation to the Equal Protection Clause?
Um,
I know you love this question.
yeah, I am so out over my skis on this question. As I understand it, and Mike and Chris get a big mop bucket to clean up after this one. But as I understand it, in modern jurisprudence, two words I can't believe are coming out of my mouth. There's this, the court has wrestled with this notion of there are private entities that do public functions. They have a public nature to them. And so so for example, I was reading a little bit over the week, for example, a private nursing home, but it may take federal monies. So it's a private company, but it serves a public function. This had a lot to do with, back in the 90s when there was a lot of discussion whether churches or communities of faith should be involved in social agendas like drug rehab, drug rehabilitation programs and whatnot. Do they fall under the 14th Amendment's Equal Protection Clause, even though they're a private firm? So I think one of the rationales has been, well, if you're a private thing, you're not immune from the 14th Amendment because you're doing public functions. Another thing that they have done is, which I'm not sophisticated enough to understand this, but there's also this notion of if there's policies done by a private organization, that if it has, I wrote this down, discriminatory intent and had adverse discriminatory impact, those fall under the court's purview as to sort out whether the equal protection applies. So but all of this is because, I find it interesting historically that right out of the chute, Congress creates one of the most sweeping civil rights pieces of legislation in 1875 that addresses all kinds of private entities, theaters and restaurants and transportation and hotels. All of those are private entities, but Congress, the people, these are not dummies. They're passing a law that clearly addresses private entities that would be restricted in their discriminatory capacities. And then the Supreme Court again reverse, we mentioned before in 1883 says, now we're going to stick with this state action doctrine. Only state entities are under the 14th. And since then we've been wrestling with it. And I think in the mid 20th century, they kind of came back to that notion that maybe private companies, private entities do have some kind of responsibilities under the 14th.
Well, and I'm glad you made that distinction. There's private public and there's private private.
Yep.
So we look at privately owned golf courses. Help me out, Chris. Who runs the Masters?
That would be Augusta National.
Augusta National is private. Augusta National, by all constitutional principle, has the right to discriminate based upon race, gender, or whatever, because it's private. But then there's private public, your grocery stores that serve the public. Now, here's one, and I'll ask Chris and Mike, because I know you probably have something to add to what Tim said, but are you guys familiar with, I know Mike is, Costco? Does Costco exist out there in your lands, gentlemen?
Oh yeah, we have Costco. We're getting into we're about the 20th century. We're getting there.
Okay, well, I don't know anything. I didn't know there was a lake next to Wisconsin, so that tells you my knowledge base of your
two lakes, aren't there? And
there could be. There could be. So Costco charges a fee, a membership fee. Is it private or private public? Can Costco discriminate based upon Tim's explanation?
Wow, I hadn't considered that. No, I don't think they can. I don't think they can discriminate based on race, color, gender, ethnicity, religion. They can discriminate if you don't pay the fee. I guess the color would be green. So yeah, they can, if you don't pay the membership fee, then you don't get to shop
Well,
there.
how's that differ from Augusta? Augusta charges a fee.
Yeah, they do. And you won't find a lot of public school teachers playing there.
Yeah, that's
Because
true.
the membership is 6 figures and the annual dues are 5 figures.
I understand. It doesn't matter. It doesn't, my point is the principle here is right. Costco charges a fee. All right. And so, so therefore that makes them private. They can discriminate on membership.
What I think that the thing is with Costco is they, their fee is not 6 figures and the annual membership is not 5 figures. So they don't want to be exclusive and they don't want to alienate the public, right? They want to try and increase their membership, not decrease their membership, and they can't be selective. So I don't know if it's been adjudicated. But I would not imagine that Costco would want to be in the business of Augusta National and keeping women from shopping at Costco.
Well, why do they charge a fee at all?
Costco or Augusta National?
Costco.
So you can reap the benefits of going home with 170 rolls of toilet paper in one package, I guess. I don't know.
And by the way, this came up in my classroom as I was, trying to distinguish between private and private public. A fairly sharp student says, oh, okay, Mr. Richmond, what about Costco? And, I tried to do that two-step and, eventually, that's a really interesting question. Why don't you go look that up? Things that us, lazy teachers do. So that's why I brought it up, because I've never really been able to come up with an answer that I'm comfortable with. Mike?
Well, I just want to tell the students, I'm not sufficiently prepped to answer this, but there is a lot of case law on this that I'll try to dig up and put into our show notes. I do think another way to think about this is that under Section 5, as we've discussed, Congress can enact statutes, right? So I know we're going to talk about affirmative action here in a second. Like my university, University of San Diego. University of San Diego is not bound by the Equal Protection Clause in what it does with admissions, but it is bound by the 1964 Civil Rights Act. So in these cases that are before the Supreme Court right now, University of North Carolina, the claim there is that the admissions policies violate the Equal Protection Clause. And for Harvard, the claim is that they violate that portion of the Civil Rights Act, Title VII.
To help out, Mike, but isn't that because the University of San Diego and Harvard receive federal and state funding?
Sure. That's one of the ways in which you can show that there is this like public connection or this publicness, as Tim was talking about. And just to go back to something I was saying earlier, it doesn't have to be this hard if we're good with our language, right? I mean, the South African Constitution has a pretty robust equal protection clause that I'll talk about here in a second. And they're pretty clear that the Equal Protection Clause and all the rights apply to private persons and companies and state actors. I mean, they just state it in one sentence, and then all this debate is gone. I think our Constitution, we tend to get into these knots because our language is a bit general and a bit vague, and I understand the benefits of that. Believe me, I don't want our Constitution to be a volume this thick, but I do think that this issue wrapped up with the fact that we've already talked about in the previous episodes, that it's almost near impossible to amend the Constitution, means that it's hard for the Constitution to reflect some of the day-to-day, I think, norms and just political and social practices that we have going on.
Yeah, I just think, I've believed this now for a while, that the framers were they all are, that kid we've all had in the classroom, really smart and a smart ass. And they decided to screw with our minds in usufruct, for previous generations. And we're going to write this language so convoluted, fuzzy, you guys are going to pull your hair out trying to figure out what it means. That's my view of the framers, Kavanaugh.
Well, I think in dealing with the 14th Amendment, as I was quoting Bingham earlier, and there's so much has been written what these guys said, it's clear what they intended, right?
Okay, here's my problem. Is Bingham does it, but it's not ratified by Bingham.
Right.
Just because one guy writes it does not encompass then the meaning of the amendment or the statute or whatever, because it's not approved or ratified by that one person.
That's why I would say it's important to look at the Civil Rights Act of 1875. If you want to know what Bingham and others in Congress intended, the mechanism is the Civil Rights Act of 75. That'll give you a good picture of what they intended. And then the court says no.
And 75, the Civil Rights Act of 1875 really reiterates that very thing.
Yep.
And I'm going to tell you right now, the reason it doesn't happen is because of racism. It doesn't happen because we are not about to give these newly freed people the equal protection of the laws that the 14th Amendment calls for. So this is why we're going to nibble at the edges. And this is why you have the court come in and strike down the Civil Rights Act of 1875. So the whole purpose, I mean, if you think it, this is what was intended. And then in practice, we put it into practice, especially after Reconstruction, it doesn't go anywhere. That's why I said the window was open, but then it closes. We had a moment there that we didn't reconcile, that we have never really reconciled with, is because of the racism that existed in this country.
Well, the big rebuttal to that, I always liked, it was the Chinese
Yick Wo versus Hopkins.
Yick Wo, yeah. I mean, that's an interesting case because the court looked at it and said, on its face, that law is not discriminatory, but the effect is highly discriminatory. So remarkably, they struck that municipal ordinance down, not on its face, but as the impact of a policy, which I think is way forward looking. I think that was in the 1880s as well. Yick Wo was.
Yeah. You're right, but the court has been super reluctant to use disparate impact as evidence to show. They really want to, and it just means it's a lot of people are handcuffed to show that intent.
So, Professor Kavanaugh, let's just cut to the core, because discrimination is an action. Bigotry, racism is a belief, but discrimination is an action. Is it ever legally justifiable to discriminate in this country? That is, for government and government-related entities, to discriminate against a group or an individual, given that we do have an equal protection clause?
Of course it is. I channeled the late, great Stan Harris. Have you guys met Stan, who was a longtime We the People teacher from Indiana, very successful, then became state coordinator for the state of Indiana for a while. And I stole this from him. All laws discriminate, if you think about it. And case in point, tomorrow's election day, but 16-year-olds don't get to vote. Why not? I have some kids that would like to drive, but they can't because they're 12. So we put laws in place to limit human behavior. And in essence, by limiting human behavior, we are discriminating. Now, the question becomes, can we apply the laws equally and fairly? That becomes the issue, I think, in terms of discrimination. And a case in point, Dave, we talk about bigotry and prejudice, and we see those beliefs get put into action in various laws throughout history. So is it ever permissible? Yeah, of course it's permissible for laws to discriminate. But again, you have to have that compelling state interest that we mentioned before. And students, what that means is you have to have the government has to have a damn good reason for eliminating that. But, driver's license and voting, we limit that to people of a certain age. Renting a car, you can't rent a car till you're 25. I've never understood that one. Yeah, laws. So I guess as long as it is not, I'm beginning.
Well, do you have to have a compelling state? Does the government have to have a compelling state interest when it applies to age? It seems you're talking about.
I don't know what. You've got that rational basis test too. I don't want a blind bus driver, or I don't want. Fill in. There's all kinds. Isn't there this? least restrictive means kind of apply in this? Again, I'm way over my skis here on this, but I mean, there's all kinds, to Chris's point, there's all kinds of policies that just make sense. And the state doesn't have to get to that highest compelling state argument as long as they can convince a judge that there's a rational basis for their, quote, discriminatory policy.
I would have the students look at the 14th Amendment and show me where a rational basis or compelling state interest is there. It's just to drive home the point. These are justice-made doctrines. Like if I put on my Hugo Black lens, right? I mean, Hugo Black famously said, no law means no law. No, nor deny any person within its jurisdiction the equal protection of the laws. Now, that should mean, like, one of the ways we discriminate is obviously in our tax policy, right? Does that mean we should all be taxed at the same rate? I mean, there's a way to read this, but you can't read the 14th Amendment without understanding the social and political context that it was written, right? And it took the court quite a while. I mean, it's not until Caroline Product's footnote 4 where the court said there are certain suspect classifications that we think deserve different treatment. But again, this is the justices in that court deciding, and then every other bench after that playing within these rules. There are other constitutions in the world, students, where the judges don't get to make up these tests. The Constitution tells them what the test shall be, whether it's a balancing test, whether it's a category test, whether it is a compelling state interest. I mean, there are just other ways to bake this cake. Or do you bake cakes? Do you bake pies? I don't know. There's other ways to do this.
That's a different case. That's a different case.
And the fact that the justices have done this has meant that over time, they have created other not quite so suspect categories. Like gender is not treated quite the same way as race, right? But why? I mean, there are historical reasons, obviously, I think, but it's because justices decided they were going to do that. Ruth Bader Ginsburg made a pretty compelling argument why that should be the case when she was an attorney. I don't know why I'm really frustrated today with our court and with our.
Well, one of the things Professor Green mentions in his book, and I'm going to really butcher this paraphrase, but to think about, and I sort of not to get away from David's question about laws discriminating, but the idea that whether or not you enjoy a right depends on its classification. It's these classifications that we're alluding to, that you guys are talking about, that established by the court. So it's only a right if, or it's not a right if, in these classifications, which is really kind of weird if you think about it.
It's rational.
Are we back to common law?
Possibly so, but I'm sorry, we have to make those kind of distinctions, or we do have 8-year-olds with driver licenses and blind people as bus drivers there. So you have to draw distinctions, whether you call them distinctions or classifications. You do have to draw some lines, and at least for a while, all right, the court was very clear that when it came to race, and if we look at it, if we're using rational basis, the government almost always wins. But if we're using compelling state interest, the government almost always loses, because we're looking at a distinction or classification of race. And it's really, really hard. Not so hard for this court possibly, but it's been really, really hard for, any court to justify discrimination based upon race. Gender, again, is a little bit more complicated because not only of history, but of culture. There, and of biological differences. Do we really want to diminish some of those biological differences in how the law treats individuals? Again, that's more of a rhetorical question there, but something to think about. And time means we have to, move on here. And so, and I know Professor Williams here is going to give us a really good comparative, probably perspective. But just recently, the court heard, I don't know what number this is in the affirmative action journey. I can think probably at least 9 or 10 other affirmative action cases, but this does deal specifically with college admissions. So one of the biggest issues, Mike, being discussed in our national community is the policy of affirmative action, which since the Bakke decision in the 1970s and Grutter versus Bollinger in the 2000 cases have allowed race to be a consideration when it comes to college admissions. Is this policy consistent? Using race for admissions, is that consistent with the Equal Protection Clause, which intended to outlaw race-based policies?
Well, that's loaded the way you just did that. I like that.
Dang right.
That was like a slider. That came in looking like a fastball and then all of a sudden dipped. All right.
Okay. My slider doesn't, all my pitches, none of them look like a fastball, even my fastball. So it's a fair question, though, if race, if the purpose of the 14th Amendment is to try to eliminate race, all right, as a, discriminatory factor.
Yeah.
How can you then justify race to fight discrimination? I think you know where I'm coming from.
I do. And I would, and this is where the historians on the call can support me on this, although I think Chris has kind of already made this argument. I would argue that the 14th Amendment was not just about not having race be a factor. I would say that the 14th Amendment is passed during a period of Reconstruction where there are very proactive policies being considered and in some cases being implemented that recognize the history is so plain, it feels kind of silly to have to state this, right? That this idea of after 250 odd years of slavery, to kind of declare, okay, the race is even now, we're not going to consider race at all, doesn't seem to be in the spirit of what the Civil War, or at least my interpretation of what it was about. Moving forward 100 years to the 1964-65 Civil Rights Act, of which Lyndon Johnson signed, he said that very thing. He said, surely we can't expect, after hundreds of years of using race to discriminate, we can't expect to just have everything be equal. Now, is that in the text? No, it's not. But it's also not in the text that we shouldn't take into account of these historical factors. And what the Bakke case did, think about it. It's 1978. It's UC Berkeley. It's the 1970s.
UC Davis.
UC Davis. Sorry. There are decades of not allowing Black individuals into a university because they're Black. They adopt a policy and they say, we're going to set up a quota system to allow in so many Black students because of past societal discrimination against them. And the court basically said, we don't like that reason. You can do it for diversity. If you tell us you want diversity, it's okay, and you can't do quotas. But that Bakke decision sets us up on this trajectory where now we have to think about diversity. The 1965 Immigration Act complicates things because we reverse decades of discriminatory patterns where we're not letting in people. And now all of a sudden, we have people coming from all different walks of life and all different folks who are going to be considered minorities here in the United States. And I'm sympathetic to the argument of should a Black person from Nigeria get the same protections as someone whose ancestors were slaves? I would argue that no. I think being Black in America is being Black in America. I think there's plenty of examples of the police don't ask whether you're Nigerian or not when they pull you over. But to me, what blew this whole thing up was that at the very beginning, we should have just recognized that we should have a series of policies that tried to make up for the injustice that we had done for hundreds of years. And by not doing that, we set up this doctrine now where Sandra O'Connor can say in 2003, well, I think in about 25 years, we'll be done with affirmative action. And I'm just doing the math here. The first affirmative action policy was John Kennedy in 1961 through executive order. And let's say we go through 2028. does that really make up for these hundreds of years? I don't know. It's just politically and socially, economically, I don't buy it. Constitutionally, is there a strong argument that it doesn't say that race should be used as a way to make up for past discrimination? It doesn't. And just students, I'll put into our notes, the South African Constitution does. The South African Constitution says equal protection of the laws, except Parliament can pass laws based on race if it's meant to help those who were disadvantaged during apartheid. I mean, they just say it. So there is another way to do this. So sorry if that was a little off point or anything, but that's my feeling.
No, I'm feeling all warm and fuzzy about that response. Chris, Tim, anything to add?
I just think it's that the catchphrase, I heard Michael say it without necessarily saying it, is to right past wrongs. Why do we have affirmative action programs? To right past wrongs? And I think it's no, I'm not going to go there. So I think that, David, as you alluded to, we've had multiple cases. I want to go back to the Fisher v. Texas case. That actually were two cases, and you look at the way Texas has done their program, I thought was actually solid. But then I listened to a professor the other day, I think on NPR, talking about it and saying actually it was not having the desired effect in terms of admission policies. And don't forget, for the students watching this, obviously the focus on affirmative action is race, but the largest group to be benefactors of affirmative action programs have been women. An overwhelming majority of opening doors for women, the doors that have been closed in the past as well. So make sure you take that into consideration when you're grappling with this topic.
I mean, on college campuses, I think Asians have been beneficiaries of affirmative action programs too.
Well, not Harvard.
Well, UW Madison, I'd say so, because that's how UW-Madison checks the diversity box, by having minorities on campus.
Yeah, well, and most definitely the University of California system, after the state abolished race-based admissions into their state university system, you saw a very significant change in admissions, and certain elements of the Asian population benefited greatly there. So again, unfortunately, time is always our enemy, because I could go for another hour on this topic, although that would be considered a violation of the international human rights for Professor Moore.
That's right. It'd be cruel and unusual.
It'd be cruel and unusual. So let's close as we normally do with insights, recommendations to students and teachers about the totality of this question, and how they things they might want to think about as they prepare to present. So again, since I know this was not one of your favorites, Professor Moore, because again, it really is targeted as a legal question.
Oh yeah.
I believe in all three parts of it, and I did as best as I could to bring in.
And I appreciate it, David.
Yeah. So thoughts you have for teachers and students?
Well, I would. We the People text in on their equal protection chapter does an interesting thing. They start out with this discussion about, is there a difference between equality of opportunity and equality of outcomes?
Conditions.
Yeah. And so I would recommend to students, you're going to fight about this, all of these policies. You're going to fight, you're going to have different opinions on what your preferences are in a particular court case that you run across or we've mentioned. But I would suggest, if you can articulate, and there's that fine line, there's always that fine line between opportunity and condition. If you can articulate your view on a particular case and how it worked out in the framework of you're seeing it as outcomes or you're seeing it as opportunity, I think judges that hear your argument will hear that you've thought about it beyond the legal. You're thinking about it beyond the legal and the constitutional law. So I'd frame your defense or critique of cases in the context of opportunity or whether it's outcomes that you're thinking about when you look at a particular case.
Professor Cavanaugh.
I would agree with Tim there, because it sounds to me like we're back to our discussion about higher law for a second. What I mean, we have the constitutional law, but is there a higher law? And I would again refer students to Dr. King's letter from Birmingham jail for a discussion of that, or at least in writing about that. I think for this question, I think this. There can be a lot of passion in this question, and that is not a bad thing, right? That is not a bad thing. But because it is, I don't want to say controversial, but because there is a lot of passion, be prepared to at least recognize the opposite side of whichever your panel or the members of your group on Unit 3 take, right? Because there's so many different ways and so many different angles to approach some of these issues, especially under the 14th Amendment. Anticipate getting pushback from judges on your arguments, and be prepared for that pushback. And again, I say this, I've said this before, stick to your guns, right? Make those arguments, you make those bold arguments if you need to, but be prepared for that pushback from good judges that will push back to see how well you are gonna stick to your guns, and make sure those arguments are based in the 12 steps to forming a good we the people argument, when the last of those is obviously your opinion. I think, but be prepared for passion in this, and if you can disconnect your passion from questions you may get. And I don't know if that makes sense, because I know that I get worked up about certain things that I get fired up about, and it's hard for me to take a breath and listen sometimes. So be prepared to take a breath and listen to what the judges are saying in this question.
Professor Williams.
Yeah, I agree with both those excellent reflections. I would say that while this is a question that is going to force you to somewhat look at some of the constitutional and court stuff, I would find a way to have in your toolbox some of the things that Tim and Chris brought up, and Dave, about the legislation and this interplay between Congress and courts. We didn't bring up the fact that Congress, in I think it was 1866, wrote a pretty robust Civil Rights Act that the court shut down, which is one of the reasons we have the 14th Amendment. So there's this interplay over time between courts and Congress. Courts have tended to get the last say, and I don't think that's necessarily the way it has to be. But I think looking at that interplay is important. And I also, while I don't know if I would lead with this in your statements, but I think it is notable that very few countries, or no countries, who have adopted constitutions in the 20th century have copied and pasted our Equal Protection Clause or our 14th Amendment when thinking about how to protect rights equally. And I think this discussion kind of shows maybe a reason for that. I'll put into the show notes some information on South Africa that you might have. I also think that India and to some extent Brazil are good cases just for you to just have a basic understanding of how equal protection is done a little differently in places in the world. And to have that ready for your Q&A, I don't think that should be in your statement necessarily, but to show that there are other ways of doing this, I think could be compelling for judges.
And the only thing I'd mention is, 25 years ago, if, when I was coaching this program, if you would have asked, I was immersed in case law, and I would have had, 25 cases, students are going to have these cases kind of stuff. And then I came across this guy from Wisconsin, and he's changed the whole way I think. And so now if I'm judging, I want to know the history and context of these provisions of the 14th Amendment. So although it may not necessarily go into your opening statement, you do need to be prepared to talk about the history of the 14th Amendment and those specific provisions as we tried to open up tonight. So our next session, we're going to actually have a wonderful guest with us, and we're going to be talking about the privileges and immunities of citizenship, as well as some policy on immigration here. So it'll be a pretty dynamic discussion. So until that time, peace, love, yogurt tacos. Bye-bye, bye bonds.